Welcome back to the Office Hours Weekly Q&A number 4. It's 2:05 Eastern Standard Time, and I'm Mike Rekola, and this is the NonDē Filmmaking Legal Lab. I'm here to be an educational resource for the next 15 minutes. First, before we begin, let's go over the typical disclaimers, aka the rules of the road. I am an attorney, but I am not your attorney. Nothing we say here creates an attorney-client relationship. This is an educational guidance tool for independent film community. If you have a specific legal emergency, please hire local counsel. Secondly, if you come up on stage today, please do not share any personal or sensitive information. It's best to keep all questions hypothetical rather than asking direct questions about specific people who you might plan to sue or the problems you have with them. Finally, if you'd like to ask a question, you can type it in the chat, or if you'd like to come up on stage, please put the waving hand emoji in the chat and I'll bring you up on stage. When you do, I'll ask you to please introduce yourself, give us a quick log line, and affirmatively state that you understand that this is for educational purposes and that no attorney-client relationship is formed today. So let's look at the board. Okay, guys, let's see. I don't know where the chat went on today. Here we go. There's the chat. So if anyone has any questions, please put the raise your hand emoji in the chat and I'll bring you up on board. As we're waiting for more questions to populate, I checked the queue this week and it seemed like there wasn't any questions. And usually when I release kind of fun stuff like the crew deal memos, I get 100 of questions. But with this week, I dropped some of the biggest contracts yet that you can review, from the director's employment agreement to the composer agreement and to the sync license agreement. Silence tells me generally one thing, that people aren't sure how to use it or they might be intimidated by it. These contracts can be scary. They're the ones that involve intellectual property and copyright transfers. And since no one asked questions, I'll probably just end up talking today about the triangle of ownership. So let's first visualize what a chain of title is. Here, in the reality of filmmaking is that no one tells you about is, if you don't own your movie, you really own nothing. So when you shoot a film, you're actually capturing a bunch of other people's copyrights. When you're shooting, you're capturing the cinematographer's copyrights for the framing. You're copying the copyrights of the director's blocking. You're capturing the copyrights of the writer's words. You're capturing the copyrights of the music and how it's all connected. So like I said, when you shoot a film, you're actually capturing a bunch of other people's rights. The director owns the visuals, the composer owns the music, and the screenwriter owns the script. If you do not have the right contracts for your movie, it's just a collection of their property rights that is being held hostage. So this week, we released the tools to take those rights back. First, the director's agreement. When I talked in this video, I hammered home the importance of pay for play. This is just one simple clause that I released in that contract. It states that if anything goes south with a director, you don't need any cause to release them from the project. All you need to simply do is pay them their rate that you negotiated. Otherwise, the director can usually sue you for a term called specific performance. Specific performance is a legal term where a judge could force you to let the individual direct the film because you didn't have that one clause in the contract. Because a director and a creator generally has a right to take opportunities that allow their career to grow. So that's one of the biggest things you need to have in any director's contract is a pay for play clause. You also need to have the work for hire clause, which simply states that your production company will own the copyright. And if they don't, the director will assign it. And then the third biggest thing that you need to have in any director agreement is if they are in a loan out company, they are operating under an LLC and you're paying an LLC and the LLC is signing that agreement. You need the physical person, the director themselves, to sign a separate document called an engagement letter. Otherwise, the courts will simply view that your business has a contract with that business and not that specific director. Next, we're going to look at the composer versus the sync agreement. So let's talk about music. We dropped those two contracts this week. I bet half of you might be confused on which one to use. So the composer agreement is generally when you're hiring someone to create new music from scratch. This means they are working for you, and this means that you want to own the copyright outright. That's when you use the composer agreement. You use the sync license when you want a song that they already exists. Say your friend has a band their track's already up on Spotify. That's when you use the sync license. The trap is if you use the sync license for a composer, you end up screwing yourself. A sync license is a rental, and a composer agreement is a purchase, a work made for hire. You want to own the score, not rent it. So when you do, make sure you're using the right tool for the job. Before I move on to any of the other agreements that we talked about, I just want to pause here for a moment. Does anyone have any questions? Feel free to either put them in the comments and or drop the emoji, and I'll bring you up on stage. The next thing I kind of want to talk to you about is, again, the importance of making sure that your chain of title, all the contracts and agreements that you own that line up the rights that you have as a producer, are fully integrated together. And what do I mean by that is you want to make sure you paper every aspect of the film. So you want to make sure you have the right contracts for the writer, whether that's an option agreement that converts into a purchase agreement, or whether that's a writer's agreement that's going to be a new hire where they're creating a new work for you. You want to have the proper crew deal memo for your DPs, because when they step on set, if they sign that agreement while they're on set, it's too late. They'll already own the copyright because they've already done work. They've already done prep to prepare for that role. So if you have the crew deal memo, one of the biggest things you need to realize is to get it signed before you step on set shooting, because you want to capture all the work from the beginning of the prep all the way through as part of your copyright. And then you want to look at all the accessory aspects from your director's agreements to, like I said today, your sync agreements and your composer agreements. So these are kind of just the gist of what I wanted to talk about today. If anyone has questions, please feel free to raise their hand or type them in the chat below. Otherwise, this will be just a quick, short, and sweet office hour this week. As a reminder to everyone, we do office hours every Wednesday at 2:05 Eastern Standard Time. I'm a lawyer. I'm not your lawyer, but you can come here and get business and strategy advice from me. We host them open to anyone, free subscribers to paid subscribers. We will also be doing this Monday, our first challenge. It'll be a clean chain of title sprint where I'll put forward 7 days of a curriculum that will take about 15 minutes each day to do. That will help you organize and compile your entire chain of title and lock down your legal rights to the work so that you own it. Now, some people might be stressed out because they might not have all the documents in order. That's okay. There'll be templates. There'll be walkthroughs that you can use. But the purpose of this clean chain of title sprint is to simply get you guys organized, to know what you have, what you need, and what needs to get re-signed or done with. So as we wrap up, here's your homework for the weekend. Go to the vault, download those 3 templates that I talked today, sign up for the February Sprint Challenge. Even if you aren't hiring a director today, read the work made for hire clause, get familiar with it, understand the language of ownership. Understand that if you want the copyright, they need to be a work for hire, and you need to protect it with an assignment clause. And then next week, we'll move into casting talent, as well as probably NDAs and other documents that you might need in the beginning to start up your production company. I'm going to end it here in another 30 seconds if no one has any questions. But otherwise, thank you everyone for coming out, and we'll see you next Wednesday. Again, I'm Mike Rekola from the NonDē Filmmaking Lab, and thanks for joining this week's office hours, weekly office hour number 4. Have a good day, everyone, and get to work.